Good morning, everybody. Good morning, everybody. Welcome to our webinar, our Wednesday webinar this morning. A special word of welcome to our Vice President, Francisca López, who's going to officially welcome all of you. I'd like to thank our Bilateral Chambers and the Swiss Chamber, Eve. Welcome, and it's good to have you here, as SLKB Attorneys are also a member of the Swiss Chamber and the Spanish Chamber. So we're co-hosting this morning. A special word of thanks to the Italian Chamber, Pamina, and the Belgian Chamber, Claudine. Good to have you here, good to have all the members. And it's a great honor for me to hand over to my Vice President, Francisca López, to officially welcome you all. Francisca.
Good morning, everybody, and thank you for joining us today in this seminar. Everything is fine? Can you hear me? Yes. Once again, good morning, everybody. Welcome to this seminar. Today we have with us our attorneys from Spelas, LENGERT, Kluber, and BRAUN joining us. Two of them, Fernando LENGERT and HEIKO BRAUN, will be presenting the legal effects of the coronavirus lockdown. We are all kind of unused to these new situations, and all the legal implications that appear with the lockdown and with the new regulations will be explained in the seminar. We hope you find it useful for your companies. We hope you find it useful to carry on during the next few weeks as we continue putting together all our efforts to serve our members, and of course, with the well-being of everybody in mind. So without any further delay, as I know you are all very eager to hear our presenters, I'm gonna now give the word to Fernando LENGERT, who will introduce himself, and HEIKO BRAUN, who will start the seminar with the labor law implications. Thank you very much.
Thank you, Francisca. As mentioned, my name is Fernando LENGERT, and my partner HEIKO BRAUN will speak first on the implications of labor law, so I'll hand over straight to him. Thank you.
Yes, good morning, everybody. Thank you very much, Manuela, Francisca, for the introductions. First of all, I want to speak for myself, and I'm sure also for Fernando. We hope that everyone is healthy and in good spirits. It's been, I'm sure, a rough 2 months ride for most of us on various levels. And I think before I go into my actual topic, labor law, for today, what is happening today with the webinar, where 4 different business chambers join to do something together, might be something not only in the workplace but in general that must be the way forward. There must be more of a togetherness than we had before, most likely to overcome the effects of that pandemic. With regards to labor relations and labor law, it is clear that employers and employees both have a role to play, and they need to interact to overcome or at least limit the massive adverse effects that this pandemic will have everywhere, literally everywhere. Within the scope of this webinar, I cannot cover every aspect of COVID-19 in the workplace. Since there's a lot of information out there through the media and through webinars such as this, I'm sure that a lot of the things that I will mention a little bit later is something that you have heard before. This is unfortunately unavoidable, but I do hope that I will give you some more information on matters that are probably not so known to you, but nevertheless very important. I want to cover specific topics. Just a second. The labor law implications, basically, of coming out of lockdown. We're now in stage 4, level 4, and hopefully it will be it will be coming to level 3 to hopefully very soon. So I will be speaking about the employer and the occupational health and safety requirements the employer has to adhere to. I will cover the topic of leave during COVID-19, the labor law processes during COVID-19, and rights and obligations of the employee. So the employer, now that we are slowly coming out of the lockdown, has certain obligations. There has been a directive in terms of the COVID-19 regulations, and that basically adds on to the Occupational Health and Safety Act here in South Africa. Every business has to implement a plan for the workplace that is very individual. Every business has certain requirements and needs that is unique to this specific business. So if I sell food, there's different topics that I have to work off than a place that provides legal services for all intents and purposes. So what it basically means is a plan has to be compiled by the employer for a phased return of employees in different stages, or, and this is what our president highlighted in his last public speech, is there is an encouragement that people are allowed to still work from home as much as possible in order to the employer is obliged in any event, so it doesn't matter which business he is operating in, to provide protective gear, masks, in some instances face screens, for example, the people that work at the tills in supermarkets, and sanitation liquids. There must be a minimum social distance of 1.5 meters at any time between the individual employees, but also if employees face the public. Surfaces must be disinfected frequently. Also, there is a requirement of screening for employees, whether that now means that every employee must have his temperature taken when he enters the doors or not. That it really depends. It's completely individual. And then if there are COVID-19 symptoms, the employer is obliged to isolate that employee and make sure that that employee cannot infect other people. There are special measures for vulnerable employees, which is for people that are in the defined risk groups, like people with prior diseases, asthma, diabetes, and also employees that are older than 60. And if it's possible to, if it's necessary that these people enter the workplace, there might be specific safety measures that have to be in place for them as well. Then the most important thing, as far as I'm concerned, as an attorney, we would encourage every employer to put policies and procedures for COVID-19 and the reopening of businesses into place, because it is your obligation to make sure that your employees know exactly what to do in these circumstances. It is suggested that each business has a compliance officer as well. To the topic of leave, voluntary and involuntary leave for employees. If an employee shows symptoms of COVID-19 at the workplace, there is, he has to go on sick leave. Whether it is compulsory sick leave or special paid leave, if it's not yet clear if that person really has COVID-19 or just a cold, is not clear at this moment. There's different opinions about that. As far as I'm concerned, the most important thing is that person cannot be at the workplace. So if your employee sneezes, he has to go. Not once if something enters his nostrils, but if there's constant sneezing, if there's a runny nose, if there's fever, if there is any of the symptoms that are identified to be COVID-19 symptoms, he cannot be at the workplace. There is a 6 weeks sick leave within a 36-month cycle, and that hasn't changed. It is still the same as before COVID-19 in terms of the basic conditions of employment act. Then there's annual leave. It is possible to request that the employee takes annual leave if there is no work for that employee. If that is the case, if you as employers force your employee to take annual leave, you cannot request that employee during that time of him having taken annual leave to work from home. That's very important. You cannot put your employees on annual leave and then call them and say, can you quickly do this for me? That's not possible. Then there's the question of unpaid leave. What happens if the sick leave days are exhausted, or what happens if you want to not apply for TERS or any other funds from the unemployment insurance fund, but you still don't have work for your employees? You can negotiate with your employees to say, for this further 2 weeks of stage 4 in the future, we don't know what's going to happen. Let's come to an agreement that you stay at home. Then obviously you have to apply for the temporary employee employer relief scheme funds that is administered by the UIF if sick leave is exhausted. I think for me the most important thing is communicate timelessly with your employees, and if there is a way that you can negotiate with your employee, you should do this as much as possible. The labor law processes during COVID-19. This would be, for example, disciplinary hearings. This would also be dismissals or retrenchments for operational requirements. Nothing has changed. COVID-19 has not suspended the Labor Relations Act or the Basic Conditions of Employment Act as far as protective measures for employees is concerned. So there is some challenges in these, let's say, disciplinary processes. If you do it via video conference, you must make sure that the process is fair. So language might at some points be a problem. You must make sure that the employee understands everything properly in the process. You must make sure that you document everything correctly and have the employee sign. And then at the end of the day, the most important thing is everything must be fair, procedurally fair. As far as dismissals are concerned during COVID-19, if an employee, for example, does not adhere to the COVID-19 measures of the workplace, that is, if it is a substantive breach, that could be a cause for dismissal. There's another important issue here. If a person has acquired the symptoms of COVID-19 or is infected by COVID-19, that doesn't make him incapable. You cannot dismiss somebody because he has acquired the virus. It's just that the effects of that, if he cannot do his job going forward because he is heavily affected by that in the future, then that might be a reason to dismiss for incapacity. But again, processes have to be followed. As far as retrenchments is concerned, one can retrench people for operational purposes due to COVID-19, but again, it must be fair. If one wants to terminate an employment agreement due to operational purposes, there has to be a consultation process. This is not easy if one cannot meet face to face. So one must make sure that during video conferences and similar devices, fairness rules. So if a person has a problem with the internet connection, you have to stop the meeting, you have to start a new, and you have to document everything properly. Otherwise, if an employer doesn't and fails to adhere to procedural fairness, it could become rather expensive later if the employee takes the employer to the CCMA or to the labor court. The rights and obligations of the employee. It's still governed by the employment contract, so whatever is in the contract rules. The basic conditions of Employment Act, the Labor Relations Act have not been suspended. I have mentioned that before. In general, there is a principle in South African law, no work, no pay. So if you cannot provide work for the employee, he does not have the right to be paid. This means that if you need to make a decision and you need to close down your operations, you can do so, and the employee is then bound to what the unemployment insurance funds pay. Currently, the UIF administers funds in terms of the temporary employer-employee relief scheme. From a practical point of view, I heard it's very difficult to get money out of that fund, but there is promises by our government that this will become better. What it also means, as I mentioned before, if somebody is on leave, he cannot work. So he might not be able to claim payment, but then he also doesn't have to work. The employee has a right to be protected at the place of work, which is especially true for vulnerable persons and additional measures, as I mentioned before, but also the employee has a duty to protect others, meaning fellow employees, but also members of the public, by adhering to the policies and procedures that each business has to adopt in light of this pandemic. And it's very important that an employee informs the employer of any COVID-19 symptoms he might have, and he must stay away. By way of closing, as I said before, COVID-19 penetrates basically all levels of our lives and society as a whole. There's a lot of restrictions on us posed by government. A lot of them seem random, a lot of them seem logical. There's going to be a lot more uncertainty, and we must make sure that we keep an eye open for what it actually means for our businesses and for our personal life. There are obviously more legal aspects of this virus. I have listed a few here. If you have any questions further to what I said about labor law today or any other legal implications of this pandemic, feel free to call us or write us emails. That would be it for me, and we can speak a little bit later during the question and answer session. Thank you.
HEIKO, sorry, Francisca. If you don't mind, we've received 2 questions, and seeing that we've finished with this section, can we maybe address these 2 questions right now? Would that be in order with you?
That's fine. I don't want to take time away from Fernando, but I'm happy. I don't mind. It's not a problem. So I'm happy with
what
that.
we can do is maybe I can just read them to you, and then we can address a little bit later. But the first one was actually from Pamina, where she said, would you please give us some example of a phased return at each different level? And for example, for professional services like a firm of attorneys or a chamber, when are we able to start returning, and what are the numbers that we would be able to have in the offices? That was the first question. The second question is with regards to labor law process, is it wise to halt the issuing of warnings, for example, and only do these once both parties are back to work? Number two, how important is it signing for consultation during these times? And some employees do not have IT resources to sign documents and are mostly contacted via telephones. And then and one more last question has come up, and I will send them to you so that maybe you can consider it and we can address it afterwards. And it is, what is the best platform for conducting virtual inquiries, and how does one handle the secure electronic storage and introduction of documents?
Okay. I'm not sure I took enough notes for all of these questions, but we can revisit that later. Look, the first question, it is not possible to give like a one size fits all answer to what a phased return could be, because it really depends on the individual setup of the workforce. It depends on the sheer size of the workplace. It depends on the business. It depends on the needs, and also depends on the level. Like, for example, there's quite a number of businesses that even in level 3 are not considered essential. So it really depends. What we have heard is that the general requirements that affect us all, like the social distancing of at a minimum of 1.5 meters, and that must be adhered to at all times. So let's say we have a 50 square meter office. There cannot be 10 people in the office at the same time because there's just not enough space. So that would be meant with a phased return, that one probably operates in stages. If one has the opportunity to have one early shift and one late shift, something like that. It is also suggested that one specifically attempts to make it possible for vulnerable people to continue to work from home. As far as the processes, the normal disciplinary processes are concerned, I don't think it would be advisable to halt warnings and stuff like that. If an employee conducts, or if there is misconduct, one cannot wait with putting that on record indefinitely. So the only thing is it must be fair. So if before one gives a warning, one has to have a meeting and a consultation. This could be a telephone conversation, but it must be fair. So one must make sure that the person on the other side understands. As to the signature of documents, like minutes of these disciplinary measures and record and acknowledgement of correspondence that has been received, it's very difficult. If there is a lack of facility, you cannot conduct this process in a fair manner. So there you have to then, I would suggest, wait until it's possible to meet that person face to face. Protection of electronic data, I think that is more a technical question than a legal question. I would not be able to inform you what is the best platform. I simply don't know. That is more a technical question. The only thing is, in terms of the Protection of Personal Information Act, you must be careful that you cannot be hacked. I know there has been a lot of these instances with schools and chats and stuff like that. you must do your utmost. But again, that is more technical than a legal question. Did I answer that, or is there more in these respects?
I think that was good right now, and you're quite right. If we can maybe now carry on, and can I hand over to my Vice President, Francisca López, to present to Fernando, and then we can do the final questions and answers at the end.
Of course, with pleasure. And thank you very much, HEIKO. I do think this presentation covers quite a number of issues which are very relevant for our members nowadays. And I do agree very much into keeping everything documented. You want to go through this process in a smooth way, but it's always important just to keep an eye on keeping records and try to make this phase a little bit more bearable for everybody. But at the same time, keeping everything documented is crucial. Without any further delay, I would like to introduce Fernando LENGERT. Fernando is also a partner at Spellas, LENGERT, Kluber and BRAUN, and his specialization is in commercial law. He will be addressing the issues of contracts, and without any further ado, I would like to introduce Fernando. Please take the word from me now. Thank you.
Thank you, Francisca. HEIKO, maybe you could just stop sharing and I can share my screen quickly.
Excuse me, I could not hear. Yeah, all right.
Okay. Okay, thank you. As mentioned, my discussion is about contracts in the time of coronavirus. And basically to try and assess, how do we deal with contracts, bearing in mind that certain services that were contracted for in the time of before coronavirus, how are they affected now during the lockdown, and how do we ensure that these contracts are either suspended or amended so that they can survive the lockdown and continue afterwards. Now, the issue that we're dealing with here is the force majeure, or the impossibility of performance of contracts, which is commonly known as an act of God. Is a clause in a contract that regulates the liability of parties and the effect of the contract when an extraordinary event or circumstance beyond the control of the parties prevent one or both parties from fulfilling their obligations under contract. Force majeure events can include, but are not limited to, war, terrorism, quarantine restriction, government control acts, strikes, pandemics, floods, or natural and other disasters which could not have reasonably been foreseen. A clause of this nature ordinarily terminates or suspends the existing contractual obligations between the parties. In absence of an express force majeure clause in a contract, South African common law prevails. Thus, the onus will be on the party alleging the impossibility to perform to prove that unforeseen occurrence. Parties to a contract are obliged to perform or to return what has been performed, which is enforceable by way of an enrichment action. And it must be noted that the mere fact that the supervening impossibility has made it difficult, uneconomical, or expensive for a party to perform does not mean that the performance has become impossible and would therefore not constitute a defense to non-performance. Okay, the requirements for force majeure to be, or impossibility, depends on each situation, but the main principle is that impossibility must arise after the contract was entered into. It cannot be that the contract was impossible at the time it was concluded. An example of this would be legal contracts. And only if the contract does not have a force majeure clause can a party say rely on the common law. So, for example, if the force majeure clause is in the contract, it must be followed strictly. If not, then common law would apply. Each case must be determined on a case-by-case basis to determine whether performance is actually possible. Both parties' obligation to perform is extinguished in the case of a supervening impossibility. And once the event has ceased, the contract normally would resume again unless it was terminated due to this situation. Normally the contract would again determine, or the parties would decide to cancel or not. There are other possibilities for partial impossibility, wherein the party would, receiving the service would either decide to cancel or accept reduced performance in exchange for reduced counter performance, i.e. payment. Okay, in regards to specific contracts, a perfect example is the membership fees contract, where, for example, gym fees and the like, where an act of government, such as the lockdown or quarantine restrictions due to pandemic, terminate the contract or suspend the contract temporarily until performance is possible. In other words, a case of a gym membership, if the gym is unable to perform its obligations by giving you access to the gym, then the reciprocal obligation to pay the membership fees should be suspended, and which has been done in a lot of cases. Another example of specific contracts would be school fees. Now, in order to assess school fees, we have to separate or distinguish between public and private schools. The reason for this being is that in regards to public schools in particular, it is governed by legislation. So in order to determine what the party's duties and obligations are, one has to read the legislation in that regard. That being the Schools Act. Now, with regards to public schools, the situation is a little bit easier, because although Section 40 of the Schools Act says that parents of learners in public schools are liable for school fees, they can be exempted from payment of school fees if they are unable to pay. So in this regard, it's advisable for parents who are either struggling or unable to pay school fees to immediately contact the schools as soon as the problem arises and try and arrange a deferral of school fees with them. Then with regards to private schools, this is governed by contract. So the situation's a little bit less clear, because although it's governed by contract, a lot of the private schools have implemented some form of distance learning classes by video conference. So there is a partial performance on the side of the school. However, this may not be enough, as the learner and the counterparty to the contract, which is usually the learner's parents, may not be receiving the full value for which they're paying. Thus, a remission in the school fees for the duration of the lockdown may apply. In order to determine whether the remission of school fees is applicable, one must scrutinize the contract in order to ascertain whether it makes provisions for such situation or whether it empowers the school to act to address the current crisis. The amount of remission in school fees would depend on considerations of fairness and what value the pupil continues to derive from the school during this period. This will require the school and the parents to enter into discussions to vary the terms of the agreement to make provisions for these changes in circumstances. Schools will have to adapt to these changes and pass on remissions in school fees to accommodate these changes where possible. Conversely, if a school adopts a new method of teaching without consultation with the parents, this could amount to a unilateral variation of the contract. Therefore, it is advisable for schools and parents to consult each other in order to find an amicable way forward. Next, I would like to just discuss leases, and in this regard, we separate or differentiate between residential leases and commercial leases. In respect of residential leases, this is a lot easier because most tenants would remain in occupation of the premises which they are leasing. Therefore, they would have to pay a normal rent as usual. However, that being said, the residents of complexes are not allowed to use common areas for the duration of the lockdown. Therefore, they may be able to negotiate a reduction in rent proportionate to the loss of access in the common areas. Commercial leases. In respect of commercial leases, the terms will have to be carefully reviewed. As I said, obviously, the lease would be a written contract, as in with anything else. So you'd have to review the terms of that contract to see whether the lease may be amended or varied to accommodate these changes. But most leases would limit the landlord's liability and prohibit the withholding of rent. However, if a tenant is unable to access the leased premises during the lockdown, or the landlord is unable to give the tenant access to the premises, a reduction in rental or similar relief may be due. On the other hand, although the tenant and its employees may not be able to access the premises, the tenant's assets remain on the premises, and thus they continue to receive some benefit from those premises in the manner of storage of those assets. But as such, both residential and commercial leases may require negotiation in order to amend these leases to provide for the change in circumstances that the lockdown has caused. In conclusion, and for lack of a better phrase, these are unprecedented times, and as such, they require flexible attitudes and negotiation between parties. One party cannot simply stipulate the terms of the contract be relied on as they stand if performance is not the same as it was before the lockdown. Therefore, parties are required to be flexible, to sit down, to negotiate a variation of these contracts in order to ensure that those contracts are able to continue during and after the lockdown period. One party must receive the services or goods, and the other party would naturally be required to pay for these services or goods. As such, as much as the service provider is unable to deliver or supply services or goods, the other party must receive an equivalent reduction in price. Where parties cannot agree to a variation, naturally litigation will ensue. Therefore, it is paramount that parties enter into discussions as soon as possible before a breakdown in a relationship occurs in order to agree on very terms of the contract. That is all that I have to say on contracts, but we can start or take some questions in regards to what I said or anything else that I might not have covered.
Thank you, Fernando. Thank you for that. There are a number of questions that have been submitted on the chat group. With regards to your particular one, on your section, I see that there's a question about what about fees for aftercare? My kids are in a private school and have still not given me an answer about the aftercare fees.
Yes. Well, look, with regards to aftercare, it's obviously an additional service which is not being supplied or not being rendered at this time. Now, obviously, before I say anything out of line, you have to, the first port of call is review the contract. What does the contract say about a situation like this, and what is the aftercare period being supplied for? So, for example, if there's no aftercare, the immediate thought would be if there's no service provided, then there should be no pay. But at this stage, we're uncertain as to when schools will reopen again. So you could find yourself in a situation where the school year is extended to shorten the holidays. So, for example, if a school year runs into December, then normally the school wouldn't provide school aftercare for that period. So you might find yourself saying, okay, well, I don't need to pay now for the months of, say, April and May. But then in December, you would have to pay for aftercare because those are costs that were not previously expected. But in my view, obviously, if the service is not being rendered, then it should be suspended for this time. So no service, no pay, and then once the school reopens, there must be some sort of compensation that if the schools are open for a longer period, that maybe the aftercare fees are increased to cover those periods.
Okay, thank you for that. And we've got another question that says, hi, does the same apply to universities as to private schools?
Yes, well, look, that would depend again on the contract. So obviously most universities are public universities, and there is the odd private university. So you'd have to review and have a look at the contract. But in terms of universities, the ability to render online learning would be a lot, I think more, the capability would be a lot easier for a university than it would be for a school. So you might find that they are able to actually render, if not all, but at least most of the services that they were before. But it have to be reviewed, as said before, on a case-by-case basis to see what measures the university has implemented and how much value that is the pupil receiving during this time. So it'll just depend on case by case.
Okay, thank you very much. Another question for you, Fernando. Do surveys suffice for consultation? The school seems to be using this as the main channel of getting information from parents, and then they issue out their final decisions.
Yeah, I've seen that a lot. I've come across it a lot. I can't really say whether it's right or wrong, but obviously it's not a negotiation. If you send out a survey, you submit it anonymously, and then you get the results back, it's not quite what I was referring to. I would suggest that the best manner of doing this would be in some sort of a parents' meeting. Obviously, it's difficult if you've got hundreds of parents per school, but there should be some manner of receiving comments and addressing them publicly with all the parents.
Okay. Thank you. Another question for you, Fernando, is how do you establish how much value the learner is receiving in a school or a university?
Yes, well, I've come across a few say articles on this issue. For example, obviously the first issue would be whether the student is able to receive the full curriculum for the year. I would suggest that would be your first port of call, but I noticed a lot of students were complaining that they didn't have access to libraries, the gym or the sports equipment as they would have had before. So it has to be determined whether that's actually part of the contract, that the university would provide access to those things. If not, I would, if not, and it's just the curriculum that is agreed upon, then you would have to think that the value has to be determined on the curriculum itself, and whether the student has received that, and whether they're able to complete that within the year. The one concern obviously is if, for example, the schools and universities do not open again this year, and students have to repeat the current year that they're in now in 2021, what the situation would look like then, nobody's talking about at this stage. So it'd be that would be one of the major concerns, but there is no clarity on that at this stage.
Okay, thank you very much, Fernando. Right, HEIKO, there are still two questions that some of our attendees have asked, if I can read them out. The first one being, good morning, about the labor law processes. Number one, is it wise to hold the issues of warning, for example, and only do these once both parties are back at work? And then the second question was, how important is signing for consultation during these times? And then some employees do not have IT resources to sign documents and are mostly contacted via telephone. How do you manage that?
Thank you. Yes, I answered that question relatively briefly just before Fernando held his presentation. In the meantime, I actually read the chat and I had a little bit more time to think about that. I would say, in general, again, fairness is the most important thing in labor law processes, and we must bear in mind that this really is an unprecedented situation. The problem that we face is we actually often are not allowed to get together and speak face to face. This would always be the situation that would be considered most fair. Since we all don't know how this is going to pan out, since we all don't know how long this will last, since we all don't know also how a CCMA commissioner or a labor law judge will see the question of fairness in processes, I would say, and I mean, it sounds how do I say it? It sounds wishy-washy, all right? But I would say do the best you can, all right? So if you need to speak to your employee and if you need to have a consultation with your employee because he conducted misconduct, then you must, and that can only be done via telephone. Let's say he hasn't come to work, or he insulted somebody else, or he hasn't like online or in a telephone conversation, whatever it is. I would say when you call that person, you must tell that person that you are recording this call. And then at the end of the consultation or the conversation, you ask, have you understood everything? And you must probably guide him with a summary and something. And you say, have you understood that A, B, C? So that you basically try your very best to substitute the signature with this telephone conversation. So again, use your best endeavors and do the best you can. I would not wait with disciplinary processes in general, because there is a time issue with that. The idea of a disciplinary process always is that it has to serve the purpose of preventing it for the future. And memories very often are very short term. So if I, for example, insult my fellow employee today, and then next week and in 2 weeks' time, and my employer never does anything, I will not stop doing this. So if I get hit between the horns in time, there's a good chance that I'll stop. And this is one of the functions of that process. So I would not halt processes. If it's not possible to conduct a fair hearing or a fair conversation at least, then, for example, for language barrier reasons, then you basically are forced to halt the process. But in general, I would say do it. Try to do as much as you can. Then with regards to that was also on the chat, with regards to the best platform to conduct meetings. Again, I really don't know. A few weeks ago, I heard Zoom is not as safe as Microsoft Teams, but I wouldn't know. I would say, again, speak to your IT person or speak to somebody that is in IT security. And about storage, I would say the same. You have an obligation to screen off private conversations with employees from the public and from other workers, you know, so there is an obligation on you, but what measures would be necessary, that is actually more a technical question.
Okay, wonderful. Thank you so much. Can I hand over to Francisca López to just address you all and to close this webinar for us. Francisca, please.
Sure. I would like to thank you, particularly Fernando and HEIKO, for this very interesting presentation on very critical issues which we are facing, all of us right now, from the fairness of the labor law process when we need to deal with situations we would rather not to, but that of course are always present in labor law and in relations between employers and employees, to very important issues like the schools and what parents can do on these situations. But more than that, I would like to thank Fernando and HEIKO for their availability and for their time to prepare these issues. I'm sure there have perhaps other guests who have more questions. You can always contact both in their attorney's firm, which we have already provided the details. And I would like to just thank you, everybody. Hope that we all stay safe. Wish you all the very best in these challenging times. We hope that we will pull it all together united and in good faith. And I think this is very important. Keep well and stay healthy. Thank you.
Thank you.
Thank you, HEIKO. Fernando, are you still there?
Yes, thank you. Sorry, I'm still here.
Thank you. I think, Manuela, we can now thank also the other chambers who have very kindly joined us in this seminar, and thank for the collaboration, which is always very important among us, and wish everybody a very good day. Manuela, I give it back to you.
Thank you very much, Francisca, and thank you to everyone. What I will do, a couple more questions came through, and what I will do is I will send it to both HEIKO and Fernando, who can then communicate with you. We will be sending out the recording, and we will be sending out, I see HEIKO's just put his hand up. Yes, HEIKO, can I hand over to you, please?
I don't want to have the last word, so please, you can speak after. But I just wanted to say, feel free to email us. We discussed it beforehand. So because we're attorneys and we have that reputation of charging for everything, like wounded buffaloes, we won't. So if you just have a question and that we can answer off the cuff without us sitting down and spending a lot of time in research or something, we will not charge you. So just feel free to contact us if you have questions that we can answer as if we were in this conversation, as if we would continue this webinar. It's really not a problem, and we will endeavor to answer these questions as soon as possible, but within a day. That would be something that we would try to do, to give you quick advice. So that's an offer that we have for everyone.
I would echo that. So any questions, even if it's not related to the topics we've discussed, as long as they're legal questions, then feel free to send them to us, and we will endeavor to do our best to respond as quickly as possible.
Thank you both very much. What we will do is we'll send you the presentation and the recording to everybody that has attended this webinar, and we thank you for it. And the couple last questions that came through, we will forward to both Fernando and HEIKO. So ladies and gentlemen, thank you very much. It's a great honor having you here, and we look forward to receiving you at our next webinar. Thank you.
Thank you.
Bye-bye.
Goodbye, everybody.
Bye-bye, everyone.